Earlier this month, a panel of Fifth Circuit Court judges blocked Mississippi's enforcement of a voting ban, which is part of the state's constitution. A 2-1 decision struck down the state's practice of permanently stripping voting rights from people convicted of certain felonies. This dates back to Jim Crow. Mississippi attorneys, led by State Attorney General Lynn Fitch, want the full New Orleans-based court with 16 active members to reconsider the case, saying the earlier ruling conflicts with Supreme Court precedent and rulings in other circuit courts. Kareem Crayton, the Senior Director for Voting and Representation at the Brennan Center for Justice at NYU Law. He joins us right now. So just walk us through, Kareem, exactly the impact of this. How many people does this impact? And I would assume a significant number are African American.
Thanks for the invitation, Roland. And yes, you're right. This provision that's been struck down in Mississippi affects about 10% of the Mississippi population, and a significant portion of them are African American. And interestingly, of that population, about 90% of people who are banned for life for a conviction, whether or not it has anything to do with voting, are people who no longer are in prison. So these are people out, going on with their lives, rebuilding relationships with communities, and they have no opportunity to engage in the political process. But since its inception, this provision has affected a significant number of African Americans. As you, I'm sure, know, African Americans as a percentage are the largest percentage of any other state in the country, in the state of Mississippi, and about a sixth of the African American population are affected by this provision. So there's a huge disparity in terms of its effect.
So first and foremost, when did this go into law?
So this was a provision, as in many southern states, that was first enacted following the end of the Reconstruction. In Mississippi, the good white people decided to get together and pass a constitutional amendment, a series of them in 1890. And
but hold up, that 1890 constitutional conviction, for our artists, needs to understand, it was expressly called because they were angry with the number of black people that were being elected in Mississippi. And there was only one black person who was allowed to be a delegate at that convention, which was Isaiah T. Montgomery.
All facts. And as you know, throughout the South, at the end of the Reconstruction, part of the deal in getting the federal government to basically allow southern states to do what they wanted essentially put in place the structure of Jim Crow. And part of that was supported by new constitutional provisions that had the intention of keeping African Americans out of the political process. This particular provision was a part of it. It is fair to say that the courts have, for reasons I'm not fully appreciative of, but they've determined that there isn't the kind of intent-based evidence that this particular provision was born of race animus. Nonetheless, we know that it is the case that the Constitution of this period was designed with that purpose in mind, to keep African Americans out of the political process.
And again, so folks can understand when we talk about this court's reasoning, what they said previously is that, well, later efforts were made to make changes, so therefore there was some distance created from the original intent. But the original intent was specific. See, that's what's crazy. I love these so-called originalists when it fits their own ideology or their own rationale, how they believe in originalism when the original intent was expressly and explicitly to keep black people from voting.
This is one of the oddities and sometimes frustrating parts of law, that sometimes interpretation that you get sometimes from courts doesn't match up with reality that we all see. And that's exactly as you described it, the reasoning that goes to whether or not the court would assign racial intent to the current provision, which did undergo some changes. But as you also point out, it's traceable to this provision that was originally established. And the question that the court in prior cases has grappled with is, well, is it possible ever to rid yourself of, as some people put it, the taint of race and unanimous. And in prior cases, the Fifth Circuit, dealing with a slightly different case, said, yeah, we think so. And in this case, the court essentially had to follow that existing precedent on the question as to whether or not it's born of intent, a racially invidious intent that would violate the 14th Amendment. On that issue, they had to follow what the Fifth Circuit said. But as you point out, they nonetheless got to a decision that said, well, we think for other reasons that this provision is unconstitutional, rooted in the Eighth Amendment.
Okay, so now they want to appeal. They want to appeal to the full Fifth Circuit for them to hear. Will they take that up?
Almost certainly they will, and I say that because, in part, this is a pretty different expected ruling than most people in Mississippi wanted. So they are going to push this to the limit. But also, it's fair to say this is a 2-1 decision, so it's a split panel. And one of the judges, Judge Jones, is pretty much in the center of where I think politically it's fair to say the Fifth Circuit as a whole is. So there will probably be further review. But the analysis that the court offers in this case is pretty consistent with Eighth Amendment law. That is, when you look at what is cruel and unusual, you ask yourself a general question. The analysis goes to, in our current society, are we able to say that this particular provision, whatever the challenge provision is so far outside of the norm that it's inconsistent with what we see in modern civilized society as a valid form of punishment? And that's really where the court came out and said, yeah, we think there's analysis that shows us that that is the case.
All right. Sort of time. When do we expect this to happen?
Well, the arguments will probably be scheduled, I'd assume, sometime this fall. It depends upon how quickly this court wants to rule. But I suspect the circuit as a whole, if they really, feel like there's a concern about the earlier decision that they want to make a statement of, it probably will follow fairly quickly. But I would guess in the next few months, we'll see argument, and probably either early next year or, shortly thereafter, we'd see a decision from the circuit as a whole.
All right, then. Last question for you. Is there, we talked about 10% of the population. How many people were we talking about who are impacted by this?
Well, we're talking easily tens of thousands of people. And it's, one of those things where people think about impact of, well, does it affect an election? It turns out in Mississippi, it could affect an election. You saw the last governor's races in a few of these states being really close. But beyond whether or not the margins do or don't affect an election outcome, it's always important to remember at the core of this are people who are entitled to their constitutional rights to vote. And so even if that number is a small number as sort of big aggregate measures go, it matters greatly. In particular, as you pointed out, in a state that has such a horrid racial history with respect to the treatment of African Americans. We should do right by people because it's the right thing to do as an American value.
All right, then. Kareem, great. We appreciate it. Thanks a lot.